The next case is in-rate adoption of J.P.B and M.M.B. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time for rebuttal, please let me know, as I will be keeping track of the time. The arguments are being recorded. When you present your arguments, please introduce yourself, keep your voice up, and remain behind the podium. You should not refer to children or minors or victims in your argument. You can refer to them by initials or terms like the child but not names. We have read your briefs and are ready to proceed when you are.
Thank you, Your Honors. May it please the Court, Andrew Karras on behalf of appellant adopted or natural mother Jamie Paul. I would ask to reserve 5 minutes of my time for rebuttal. We have raised 3 assignments of error, but really 2 issues in this case. I'll start with the first, which is can a person who petitions for adoption as an unmarried person receive a final decree of adoption if they are in fact married when that decree is issued? I would submit that the answer is no, for a number of reasons, starting with the plain text of the adoption statute. So Revised Code 3107.03 generally provides that unmarried persons may adopt on their own, but generally speaking, absent circumstances that are not present in this case, married persons have to adopt together. The statute says who may adopt, not who ask to adopt, not who may petition to adopt. And so I'd submit that just as a matter of plain text, the statute is concerned with standing. It's a jurisdictional standing requirement. It's not a non-jurisdictional pleading requirement. A useful illustration of that point, I think, is looking just at the very next section of the adoption code. So Chapter 3107 at Section .04, subsection A, which is about venue, by its express terms is about pleading. That is, pleading, the venue is governed by where the petitioner lives at the time they file their petition. If the General Assembly had wanted 3107.03 to operate similarly, I submit they would have used the same language, and they didn't.
Is it really a standing issue about an unmarried versus married person when we have an issue, we have a portion of the statute that dispenses with the consent from the other party? So if an unmarried person files a petition and gets married, isn't there a mechanism in the statute where she could proceed with her petition with consent of her partner? Or the court could find that consent wasn't able to be given for some reason?
So if I'm understanding your question, an unmarried person does not have to have a co-petitioner at all, even if they have a romantic cohabitant or somebody who outwardly resembles being married.
Well, I think the whole point that Judge Lanzier is getting at is how is her standing destroyed, because the whole point is she started out with standing under the statute.
Sure, and there certainly are cases that say standing is determined at the commencement of an action, but those cases involve typically, or the inverse of this situation, where a complainant does not have standing at the time a case is initiated and maybe gets an assignment of claim post-complaint. Standing being jurisdictional in nature, compels you, it is both a requirement to invoke a particular process from a court. It's also a requirement to be eligible for substantive relief.
So what I'm understanding you saying too is under the statute, if you're unmarried and living with somebody, it's fine. You can, you never get married, even though you have that person as your partner for 30 years, and they're intimately involved in everyday functions and everything else, and very involved in the child's life, that it doesn't matter. But if you marry the person, it does.
That is correct, and I don't think it's an unreasonable construction of the statute. I mean, there are policy reasons to understand it that way, which is that marriage is a status conferred by law that has its own distinct and unique set of privileges.
So I guess I want to use the statute language that I'm looking at when I ask the question. It says the failure of the other spouse to join in the petition or to support the adoption is found by the court be reason of prolonged unexplained absence, unavailability, incapacity, or circumstances that make it impossible or unreasonably difficult to obtain either the support or refusal of the other spouse. So there is a provision here, right?
Correct.
That would excuse any
Under appropriate
consent.
circumstances that are not appropriate
So
in this.
couldn't we just say the court, since this marriage happened at the last minute, that it implicitly found circumstances that made it difficult to obtain refusal or consent?
I don't think that's, I don't think so. I don't think, as that, as a matter of the plain text of that provision, I don't think that, first of all, it wasn't expressly invoked by the petitioner. I don't think it's been relied upon by the briefing in front of this court. And I don't think, the trial court relied upon that provision. Setting aside any other party's reliance, that just contemplates circumstances where the spouse is estranged and can't be joined as a co-adopter for that reason.
But it doesn't say that. It's very vague about what those circumstances are.
So I don't think even these circumstances, even like the late nature of the change in status in terms of when the decree was issued, didn't make it impractical or impossible for the spouse to be joined. I mean, they're living. The spouse in this case is living in the home. Is by all accounts a romantic cohabitant. So.
And actually is what, the biological uncle of the children? Or
Correct.
something like that? So he's all related already by blood.
Correct. I think another useful illustration of what I'm getting at is, in fact, the principal authority relied upon by Eckley, cited by the trial court, which is the M.M.B case out of the District of Columbia, which is based on different statutory language, which, again, like that language is about status at the time of petitioning, which I think that's the most salient distinction between that case decided on District of Columbia law and this case. The other, I think, most important difference between this case and the M.M.B decision is postural, which is that there are finality concerns in the M.M.B case. There was no direct appeal from a decree. In that case, there was no facially timely application to set the decree aside. Here, you have a different situation. You do have direct appeals from the final decree, and then you also have an appeal from a timely motion under Civil Rule 60B. In these consolidated proceedings.
I have a couple questions for you. First of all, how is the standing issue raised below?
Sorry.
How is the standing issue raised below?
So it was raised in, first on direct appeal, in the initial direct appeal from Mom's decrees.
So it wasn't raised below?
So it was raised initially, so the final decrees are issued. That's, when Mom first finds out about these proceedings. She raises them in the initial briefing before this court. The assignment to the panel in that initial case was vacated so that the the probate court could address the pending Civil Rule 60B motion.
Right. Which the trial court ruled against her.
Correct, and among other merits defenses, raises the standing issue as part of that briefing. Also, I would submit, to the extent your question is about error preservation, it's, like I said, an issue, standing is an issue of jurisdiction.
Well, standing can be, there's lots of case law that says standing can be waived too if it's not raised.
At the first opportunity, but I would submit that Mom.
Well, so let me just make sure I understand. If we were to affirm the court's ruling on 60B, you're out, period.
What I would say is if you, rule against this on 60B, I think, one of the ways of understanding, assignment of error 3, where we've talked mostly about adoptive mom's service efforts, is it's an alternative ground for relief on the service efforts, because there is precedent that we've cited in our brief that says failure to serve a natural parent in a manner consistent with due process makes the decree void, not voidable.
But the court said that the service was sufficient. That's my whole point.
So it did, certainly. And so moving to errors, assignments of error 2 and 3. Due process provides an attempt to provide actual notice, and the civil rules require the exercise of reasonable diligence prior to serving by publication. I submit that the record reflects neither of those things. First, on the face of the application to serve by publication, based on the facts articulated at the consent hearing, but maybe most crucially, after the consent hearing, but pre-decree, mom's attorney sent a letter to adoptive mom saying, I would like more visitation with my kids, and if we can't, if we can't work something out, I'm going to file something in the juvenile division. She does proceed to file something in the juvenile division. It's not responded to in the ordinary course. Instead, what adoptive mom does is once she has the decrees, uses those decrees in the juvenile court as a basis for dismissing the motion. So certainly she knew how to get in touch with mom before the decrees were issued.
And you're running into rebuttal time.
Okay. Okay, so with that, I would reserve the balance of my time for rebuttal unless there are any pending questions. Thank you.
Thank you.
Good morning. May it please the court, Attorney Corinne Hoover on behalf of the adopted mother in this matter. Your Honors, I think that prior to jumping in, and I can argue all of the procedural and technical issues ad nauseum, I think it's the most important to recognize that the Ohio legislature has well-established rules for when a biological parent's rights can be severed in favor of an adoption. And that centers primarily on the concept of abandonment. As this court is well aware, there's two ways that the legislature has set forth that a parent can essentially abandon their child so that their rights can be severed in favor of an adoptive parent. That is abandonment by lack of financial support or abandonment by lack of contact. Both of those are for a mere 1 year period of time. This case involves a mother who abandoned her children for 6 solid years. The case initiated in juvenile court, and I think it's important to know that in juvenile court, when my client and the child's paternal grandfather were granted joint custody of these children, in the juvenile court record, it was noted that mother's whereabouts at that time were unknown. She had a warrant out for her arrest. She had initially been served with process and that complaint, and then essentially went AWOL. After my client was given custody, that continued for a 6-year period of time. It's uncontroverted in the affidavits and in the copies of communications between the parties attached to both parties' briefs down in the probate court that mom reached out. There was some communication initially in October of 2017 via text message, and then thereafter there was no contact whatsoever. Certainly, adoptive mother had some contact with Bruce Bahana Jr., who is now the married spouse of my client, in 2020. However, that was the period of time that my client and Mr. Bahana were not in a relationship, were not residing together. Interestingly though, even if a court were to impute Mr. Bahana's contact with the biological mother during that time, the last contact they had was in January of 2020, which is still well beyond the 1-year look-back period that the probate court was to apply.
So I want to make sure I understand.
Yes.
So the correspondence that biological mother sent to adopted mother about having more visitation time, that was not within the 1-year look-back
It
period?
was not, it was in 2017. And that, at that time, mom says, I will be coming back to Ohio to stay for Christmas, and I would like to see the children. And adoptive mother responds with a thumbs up emoji, and that's the last communication. So that's in 2017. These cases were not filed until 2022. And so well beyond that.
And the action in juvenile court was filed?
The actual, in juvenile court was filed in, let's see here, October of 23, after the adoption had been granted.
Thank
So in this matter, we could take it back to, so I will address two issues then on the technical basis. The standing issue is, I think that Ohio case law is pretty clear that standing is determined at the time of filing. This is certainly an interesting case where they married weeks before the finalization in this matter. And so certainly I will tell you, and the Ohio law is void of any case law on that very issue. My argument to this court, however, would be that even if that the standing was essentially disrupted at some sort 2.5 years into the case, that it's harmless error. For the reason that if this court were to say this woman was unable to adopt, to finalize the adoption because of getting married weeks before, and remanded that matter to the trial court, the trial court, all adoptive mom has to do at that point in time is amend her petition to include her new husband. The Ohio Administrative Code, which sets forth the standards for home studies and adoption by an adoption assessor, mentions that any adult living in the home has to be evaluated in the process of the home study prior to the court approving it. The trial court had a home study, which had been completed by a licensed adoption assessor, who evaluated not only adoptive mom, but Mr. Bahana as well. Found no issue with his suitability to be around the children or the home or anything of that nature. And in fact, recommended the adoption when he was living in the home as the boyfriend to the petitioner. So if this court were to find that were an error, remand, it simply is an amended petition. The result is the same. An amended petition does not change the look-back period of time. And so the look-back period of time is there's uncontroverted evidence in this matter that mom did not attempt any contact with these children during that 1-year look-back period of time that the court was to examine.
In regard to your harmless error analysis, because otherwise I'm not sure the court would even be looking at any of this as to what would happen if we would remand. But how, if we remanded and said she lost standing and therefore the adoption was void, how do you amend that?
I agree that if you took that action, it would be difficult to amend, and so what you'd have to do is refile.
And
But
then
if it was remanded to
back
further consider, yes, correct. I do agree with that.
Thank you.
As to the issue of service, I think that the arguments of appellant are that there were due process considerations and that she did not receive actual notice. We would stipulate with the fact that she did not receive actual notice. However, I certainly disagree there's a due process consideration because the Ohio civil rules and the legislator have clearly laid out the process for service. Here is the issue is that Civil Rule 4.4 through 4.6, which as this court is well aware is the process, the applicable process matter, as well as Civil Rule 73, which specifically applies to probate court proceedings, both indicate for process, service by process, if you cannot ascertain the whereabouts of the other party. Interestingly, Civil Rule 73 does not require any particulars as how you determine that. It says that if you file an affidavit, say their whereabouts are unknown, and you cannot with reasonable diligence ascertain that, the court can approve the service by publication. That's what happened here. The arguments in appellant's briefs as far as why that may have failed, I think the reality is that they've raised these issues below in regards to the Civil Rule 60B. The court has overruled that, and the court has correctly said, we don't have to sit here and say what specific actions had to be taken. We make a determination of reasonable diligence. The fact here is this woman did not want to be found. She had 6 years that she could have stepped up and said, here I am, here's where I'm living, I'd like to have contact with my children. And she didn't do so. And so at this point in time, when these people are all related in some familial capacity, is that when this woman decided that she was going to abandon her kids, she ultimately abandoned this entire family, whom she knew had custody of her children. Not just my client, but the children's paternal grandfather didn't make any efforts during these periods of time to contact them. And she can't put forth any effort. And all the pleadings and down below where you see affidavits and attachments of text messages and communications, she doesn't set forth one attempted communication between the period of 2017 in 2020 when she had contact with the non-custodian. Interestingly, the context of those messages where she had contact with Bruce Bahana Jr. acknowledges in the content that she knew that he and my client had broken up. And so, even if you say, okay, well, that maybe somehow should have been imputed, because they eventually reconciled, did they know, or have reasonable cause to believe they could contact mother, is that even with that, it was well beyond the look-back period. She never provided an address to Mr. Bahana, never said, hey, I'm living in Ohio, here's where I'm at, none of those things. So as far as that goes, certainly I would ask this court to affirm the decision of the trial court finding that adoptive mom made her reasonable efforts to locate biological mom, and that service by process by publication was sufficient in light of the circumstances. Lastly, I will tell the court that in support of our argument, all of the adoption statutes, all of the adoption case law continually mentions that the overall and prevailing interest in adoption proceedings is the best interest of these children. Here, these children have been cared for by this woman for their entire lives. The one child left the hospital and went home with my client. The other child was 4 years old. The oldest child is now a teenager. Is that the reality is that they have only known one mother during these proceedings, during the entirety of their life. And that now all of the efforts that their biological mother have made is unfortunately way too little too late based on what the legislator has determined. The legislator could have determined that there's more than a 1-year look-back period. They could determine that there's other circumstances that the court were to look at. Unfortunately, for mother, they have not. And so the law is pretty clear on that. And so we certainly believe that in light of the best interest of the children as well, which the probate court did take into consideration in denying the 60B motion, as well as the process issue, found that the overarching concern was the best interest of the children, and that was met by granting the adoption. So we would ask this court to affirm. I have nothing further unless your honors would have questions for me. Thank you.
Okay, 4.5 minutes.
So I think the focus on mom's conduct that you heard in Appley's argument is telling insofar as it gets the analysis exactly backwards. Whether my client was hard to find is not the operative question under due process. The operative question is whether adoptive mom reasonably attempted to find her. And so, the trial court's finding that my client concealed herself, the suggestion that she did not want to be found, as much as we dispute that on the record, I think is wrong as a matter of law because it gets, again, the analysis exactly backwards. The civil rules, the adoption statute, there's no case, so far as I'm aware, that says that those protections are coextensive with due process, that they fully effectuate the notice you're entitled to under the constitutional due process clauses. In fact, we've cited cases that stand for the opposite proposition. And so the touchstone of due process is obviously notice and an opportunity to be heard. That requires an actual attempt to find where mom was, and I don't think you see one reflected in this record.
So what, the trial court did in fact say there is reasonable effort, reasonable diligence was made, okay? So what is our standard review of that?
It's an abuse of discretion. But, and the standard review being an abuse of discretion, at this point, in the development of, Ohio's laws on, the standards of review, trial courts do not have discretion to misapply the law. And here you have, an unexplained assertion that mom reached out to family and friends. We don't know, when those efforts were made. We don't know which family and friends we reached out to on this record. There's an explanation that she, searched social media. Again, not really elaborated, well, certainly not elaborated on pre-decree, and not greatly expounded upon post-decree. And to the extent that there are factual disputes over this, we've cited the Riverview Crossing case for this proposition, among others. It was inappropriate for the court to decide the Civil Rule 60B motion based on its resolution of competing factual assertions. That under case law, requires, at minimum, an evidentiary hearing. So both as it relates to, you know, our 60B assignment of error and the due process clause, I would emphasize, you know, something else that this court, as well as courts around the state, have repeatedly held, which is that the termination of a natural parent's rights to the care and control of their children is the death penalty of family law. And we would be hard-pressed to impose the death penalty following a trial at which mom did not participate, following a trial in absentia, especially where pre-decree, mom does make some communications, this is where I can be found. So for those reasons, together with the reasons articulated in our brief, I would submit that the trial court issued a decree toward a party that lacks standing under the plain text of the statute, and it erred by finding that service comported with due process, as well as the applicable civil and statutory scheme. We would ask this court to reverse and remand. I would rest on the balance of my brief unless there are questions.
Thank you both for your presentations. The court will take this matter under advisement and issue a ruling in due course. The clerk of courts will mail you a copy of the decision on the day it's released. Also, the opinions are posted on the Ohio Supreme Court website. Thank you again for your presentations.